Ma'asechet Baba Kama Daf Nun Vav. The Mishnah talked about a case where I have some animals and I make a proper fence, but then somehow the animals get out and they cause damage. Or if someone else comes and they break down the fence, the thief breaks down the fence, and then the animals go out and I lose them, or they go in damage. So who is responsible? So apropos of that, we have a following important Baraita Tanya. The following four cases, the one who does these things is not liable in a human court. You go to human court, they say, no, you don't have to pay anything. Nevertheless, they are liable in the hands of heaven. Rav Aaron Lichtenstein once wrote a famous article titled, "Is there an ethic independent of halacha?" Meaning, if you don't get punished for something, does that mean it's okay? Or there are things that are unethical, even though you don't get punished for it. So, assuming we define halacha as something that a human court can issue liability for, so the answer according to this would be yes, right? There are some things that, although the human court will not punish a person, we're going to see what they have in common is that the action is done indirectly, and so therefore the human court cannot give him punishment. Nevertheless, it's morally wrong to do these things, and therefore he still deserves punishment from heaven. If I go to your pen and I break down the wall, and the animals are in the pen, and then the animals leave and you lose them, so I am not responsible to pay for your lost animals. The Gemara will discuss whether I have to pay for the wall or not. That's a different story, but I don't have to pay for the animals because I didn't steal the animals. I just opened up the wall, and then the animals went out on their own. So it's not a nice thing to do. It's morally bad, and so I'll still get punishment from heaven, but I don't have to pay for them. Or I see a fire coming, and it's coming towards your wheat, and I take your wheat and I bend it towards the fire so that it gets lit by the fire. And if I hadn't, then the fire would have passed it by. Would not have reached it. So I cause it. Now, I didn't light it on fire. I didn't take the fire and light it. I just pushed your grain so that it will be in the way of where the fire is going. That also is indirect. I don't have to pay. Or I go and hire false witnesses to testify against you. And they go and they say that you owe, well, either me or you owe someone else money. And I hired them. Well, I didn't testify falsely myself. I only hired someone else to testify falsely. So they're the ones that did the damage directly. Mine is only indirect. Nevertheless, it's not a proper thing to do. And although I wouldn't pay, I deserve punishment from heaven. And lastly, or if I know testimony about you that would get you off the hook, I know that you already paid back, I know that you don't owe money, and I refuse to testify, I withhold the testimony, and that causes you a loss. But that's also not direct. That's just by passively not doing something and not testifying on your behalf. So although that's not a nice thing to do, and it actually violates a biblical prohibition, as we'll see, nevertheless, there's no direct action involved, and therefore I cannot be made to pay. Amar Mor, now we're going to analyze each one. If I go and tear down the wall that's protecting your animals, and so what would be the case? If it's a nice strong wall, and I go break your wall, I should be liable to pay for the wall. Okay, fine, not for the animals because they left themselves. I didn't make them leave. But how come you don't say I pay for the wall? We're talking about an unstable wall that would have broken down anyway. You would have had to break it down, right, if I didn't, or it would have fallen by itself. Okay, well, that's this case. Amar Mor. That's why I don't have to pay for the wall. In fact, as we're going to see in a minute, I might even be doing you a favor in knocking down that wall because it's so bad. It was a hazard, and you would have had to pay someone to break it down yourself. Next case, Amar Mor. I bend the grain over towards the fire. Now, what is the case? If it would be where the fire is nearby, and a regular wind would have pushed the fire, spread the fire towards the grain, and I pushed the grain over so that it will be in the way and it will catch fire. Well, then I should actually have to pay money. I would be liable in a human court also because I directly moved the grain in a spot where it was likely that it would cause that it would go on fire, because even a regular wind would make it go on fire. It can't be that. Rather, the fire was far enough away that a regular wind would not have brought it close to the wheat, but an unusual wind would bring close to the wheat. So when I pushed it over, it still was very unlikely that it would happen, and so it was not in my control, not in my expectation that this would happen. It would be like if I take your favorite shirt and I dangle it out the window just to tease you, and I'm holding on to it such that a regular wind would not blow it away. But let's say right at that moment a tornado wind comes and blows away your shirt. So I although I didn't act morally correct, just because I put your shirt in danger, but nevertheless it was beyond my control. I couldn't have expected this tornado wind to come, and that's why I don't actually have to pay you monetarily in a human court. But Rav Ashi Amar, or another explanation of this wheat case, is tamun itmar mishum deshaviyeh tamun ba'esh. It's not a case where I bent your grain over towards the fire, because in that case I'd be directly touching your grain and pushing it towards the fire. But rather, we're talking about a case where I covered your grain. I might be doing you a favor. I see fire coming, and I take a blanket or a tarp and I put it on top of the grain to protect it, but it ends up getting burned. Now, the law regarding fire is the one whose fire it is only liable for damage of things that are revealed, that you can see. But if something is hidden, then the owner of the fire does not have to pay. So now, even if I was intending to do you a favor by covering your wheat to protect it, nevertheless, now that it's covered, you cannot collect damages from the owner of the fire. And so I indirectly caused you a loss. I didn't put your grain on fire. I didn't even bring the fire any closer to it. But by covering it, I removed your ability to get payment from the one who is guilty, from the owner of the fire. Amar Mor. Next case, hasoched adeh sheker echidame ilema lenafshe mamona ba'esh alumeh ubnei adam namechayev ela lechabre. If I hire false witnesses to testify against you. Now, what is it talking about? If it's that I'm hiring them so that you will pay me money, well then, that means they said falsely that you owe me money, and you paid me money, so what, I can keep it? Obviously not. That would still be stealing. I took money that doesn't belong to me, so I would certainly have to pay you back in a human court. Rather, it means that I hired witnesses to testify that you owe money to a third party, so I'm not getting any benefit from it. If that third party still has the money around, well then he'll return it, or maybe it will never even be found out that, or maybe he doesn't have money, or maybe it won't even be found out that these were false witnesses. But I caused you to have to pay someone wrongly, but I didn't get any benefit from it. So therefore, you can't take me to court. What do I have to pay? Right? I didn't take the money from you. I don't have it, but I indirectly caused you to have to pay by hiring these false witnesses, and therefore I am morally responsible from heaven. I know testimony that will help you, but I don't say it. Now, if I'm one of two witnesses, there are two witnesses, and then I say, no, I'm not going to testify, well then, that withholding testimony that will really help you, that is a prohibition, a deoraita prohibition. The Torah says, if you don't say testimony that you know, then you bear iniquity. So the Torah says that person is guilty, although not guilty of payment, because I didn't take any money from you. It's passive, right? I didn't do an action. I just didn't testify. So, so in this case, it would be obvious that I would be liable Medinat Shamayim because I violated an explicit deoraita pasuk. So I wouldn't have to say this case is no chidush here. Ela behad, rather it's talking about a case where I'm the only witness that knows that you are innocent and you don't have to pay, and I don't come forward. Now, usually one witness is not enough to make you to get you off the hook, or one witness that, let's say you're the claimant and you want to collect money. So one witness is not enough to get you the money that you're owed because I'm only one witness. However, one witness can, if I testify and say that guy owes you money, then although the court cannot act on one witness to extract the money, it can impose a vow, and the court will say, okay, you have to vow that you don't owe the money to that guy, and so then that guy, well, more than likely will not want to swear falsely, and says, okay, fine, I'll just pay and not swear. And now by me withholding that testimony, I am taking away that leverage that you had of making the guy swear, and otherwise with that leverage you very, very well may have been able to get paid, and so I'm taking that away. But it's not direct. I mean, it's not for sure that he would have paid anyway, and so therefore it's not like I have to pay. This is only indirect damage, but still it's morally wrong because I could have helped you out with even although I'm only one witness. Okay, now those are the 4 cases that we had in this original list. But now we're going to ask about these 4 cases. All right, the 4 cases were said by Rabbi Yehoshua, and we're going to say, wait, are these the only 4 cases in the world? Vetu leka. Now we're going to list a whole bunch of more cases where one is not liable in the human court, but is still morally liable in the heavenly court. V'ha'ika, now as mnemonic to remember them, siman ha'oseh besam v'shalech havero nishbar. So the first one is ha'oseh, starts with ha'oseh melacha b'mei chatat u'prat chatat patur midinei adam v'chaya b'dinei shamayim. If I take the water that is designated to mix with the para aduma ashes, that water is holy, is special, set aside, and I'm not allowed to use it. If I use it, then it will be disqualified. Or the para aduma itself, that is set aside to be a para aduma, I'm not allowed to use it. And if I use it, then it's disqualified. But in these cases, if I do use it, I am not liable in a human court, only bidinei shamayim. We're talking about a case where I'm not using it directly. It's like I'm drinking the water, but let's say I use it as a counterweight. I put it on the other side of a scale, and so I'm leaving the thing the same. Nevertheless, that usage is not allowed, and now I'm not going to have to pay for it, but still, that's another example of chaya b'dinei shamayim. Another one, vayika noten sam hamavet bifnei habehemat chavero patur midinei adam chaya b'dinei shamayim. If I put poison in front of someone else's animal, and it eats the poison and dies, I don't have to pay in court because I didn't directly kill it. I didn't even touch it. I didn't put my hands on it. Right? Who asked it to eat that poison? But nevertheless, I am morally responsible and deserve punishment in the hands of heaven. If I take some a fire and I entrust it into the hands of a deaf person or someone who's mentally incapacitated or a minor, I am not liable in the hands of a human court because I didn't do it directly. I just gave it to this irresponsible person. But because I gave it to this irresponsible person, I am liable b'dinei shamayim. If I go hide behind the door and then when you come, I jump out and scream in your ear and cause you to be frightened, but I don't touch you. So you could bring me to court, but I'm not going to have to pay. Pay for what? I didn't touch you. However, it's still, I am liable b'dinei shamayim for causing you that fear and pain. והאיכה נשברה כדור ברשות הרבים ולא סילקה, נפלה גמלו ולא העמידה. רבי מאיר מחייב בהזקה, וחכמים אומרים פטור בדיני אדם וחייב בדיני שמיים. Or a last case of if my jug breaks in the middle of the street. Not that I smash it on purpose, but I tripped and my jug broke, or my camel fell in the middle of the street, and either I didn't pick up the pieces of the jug, and I did not pick up my camel and make it stand up, and then someone else comes and trips on the pieces of the jug or on the camel that's lying down. So according to the Meir, I am liable because I'm liable to make sure to pick up those pieces right away or pick up the camel as soon as possible. However, Chachamim say, no, in this case also, I do not have to pay in a human court because this is indirect. I didn't want this to be that. I didn't put the stumbling block there on purpose. It fell. And so I didn't want it to be there. I don't have to pay directly. Nevertheless, I should have put more effort into cleaning it up or standing there to make sure nobody would trip on it and so I'm nevertheless liable b'dinei shamayim. So now the question to Rabbi Yoshua is, why'd you say here are 4 cases, as if there's only 4 cases? Here we had a whole bunch more. So we answer, in miha ikatuba v'hana istericha le ma'odetema b'dinei shamayim namila lechayev kamashmalan. So you're right, there are many more cases. Nevertheless, Rabbi Yoshua wanted to teach these cases because there's a particular chidush in each one of them that I might have thought I would not be liable, not even b'dinei shamayim in each of these cases. And then we're going to go back over the 4 cases and explain why we might have thought that there's an absolutely 0 liability, not even morally. As first case, hapores gader b'fnei behemat chavero, mahu detema kevan de mistereh ka'eh ma'aved b'dinei shamayim nami lechayev kamashmalan. In the first case, where you put up a rickety wall to protect your animals, and I come and break down the wall. So you want me to what? You want me to pay for the wall? What did I do? The wall was going to come down anyway. In fact, I did you a favor. You don't have to hire a demolition company to knock down this wall. So I might have thought that I'm not liable at all because the wall was going to come down, and so I just made it come down a little faster, but maybe I would not be liable, not even b'dinei shamayim. So now Rabbi Yoshua comes to teach that I am liable b'dinei shamayim. Maybe you had a plan, you were going to do it tomorrow or in 3 days from now, and you would have been able to safeguard your sheep. In the meantime, I did it now when you weren't ready, and then the sheep got away. So that's not a very nice thing to do. So I'm still chayab b'dinei shamayim, although not in a human court. Hakofef kamato shel chavero nameh. Mahu detema lema mi havayadana da'atya ruach she'ena mesuya u'b'dinei shamayim nami la lechayev kamashmalan. If I bend your grain towards the fire, and an unusual wind comes and takes it away, so I might have thought, well, how was I supposed to know that an unusual wind, this sudden tornado, would come out of nowhere and move and push the fire and burn your grain? So I couldn't have expected that, and therefore maybe I would not be liable, not even b'dinei shamayim. And that's what Yoshua has to teach a chidush. In this case, yeah, still I put your grain in danger. Why? Who was I who asked you to move my grain at all? And therefore I am at least liable b'dinei shamayim. Rav Asher tamun itemar. And we had a second interpretation of that case. Rav Asher said that's talking about a case where I cover the grain. There also I might have thought ana kasuya kesite nihalach b'dinei shamayim nami lalachem kamashmalan. I might say I covered it for you to protect it. I was doing you a favor, so I shouldn't be liable at all, not even b'dinei shamayim. And so the Rabbi Yoshua comes to teach, yeah, but still indirectly I prevented you from being able to collect damages for it because it was hidden. And so he had to teach that, yes, there is heavenly liability. Divrei harav, divrei hatamid, divrei mishamim. Ubnei shamayim namid lechayev kamashmalan. In the case where I hire false witnesses to make you pay someone else, I might have thought that I could tell the witnesses, wait, if a teacher tells you something and a student tells you something, don't you listen to the teacher? So too here, there's a pasuk, right? God said, don't be a false witness, and I said, be a false witness. So what's the difference? What I said, you shouldn't have listened to me. And shaliach ledvar avera. So you might have thought in this case I would not be liable, not even b'dinei shamayim, because the witnesses should have known better and followed the pasuk. And that's what Rabbi Yoshua says in this case also. Although I'm not directly responsible, I didn't even get any benefit from it. I made you pay someone else. And the witnesses should have known better not to violate a Torah law. Nevertheless, I am indirectly responsible and therefore liable b'dinei shamayim. Okay, and the last case of Rabbi Yoshua is if I withhold testimony from a case that would have helped you, and we said this talking about where I'm only one witness. So I could could say, wait, maybe I should not be liable at all, because who says that even if I do come and testify, that the other guy would have admitted rather than swear? Maybe he would have sworn falsely, and he wasn't going to pay you anyway, and therefore I should not be liable, not even in the hands of heaven, because my withholding my testimony of one witness made no difference to you. And therefore, the Yeshua says, and even in this case, where you might have thought that, not so. There is some likelihood that by coming and testifying, even as one witness, that will give you some leverage that you can make him swear. And maybe you could have used that leverage to collect money. And therefore, although I'm not directly responsible and therefore not monetarily liable, nevertheless, I am liable in the court of heaven. All right, the Mishnah then teaches, Nifresa balayla o sheparsu halistim. If I made a proper gate around my animals, and it somehow was breached at night. The point of at night is that I was sleeping, so I wouldn't have been responsible to see it and fix it right away. But anyway, somehow it gets broken at night, or thieves come and they break it. If the animal goes and causes damage, I am not liable. Amar Rabba shehatra. Rabba says that this law, that if the sheep somehow break out at night and cause damage, I am not liable. That's only if they tunnel under. How did they get out? If I put a nice wall there, it means that they tunneled underneath, and that's how they got out. And I am not liable because that's a very unusual thing. How was I supposed to know that they're going to tunnel under the wall? So now we ask, what if they didn't tunnel under the wall, but rather the animals inside broke through the wall somehow in the middle of the night? They broke through the wall and caused damage, then I would be liable? Well, let's see. What's the subcase? If I put up a proper, normal wall, then why should I be liable? What could I have done? I put a normal wall, and so I did my proper safeguarding, and we saw if I put up my proper safeguarding, then I should not be liable. So, we're talking about an unstable. I put an unstable wall. Now, well, if I put a shaky wall and it broke through the wall, I would be liable. That I understand. But if it tunnels underneath, how come over there you're saying patur? This would be a case where I start off being negligent, even though in the end it happened by accident. This is similar to a case, let's say I'm driving drunk, and then the other guy passes a red, and I smash into him. So I am still liable, even though I couldn't have done anything. He passed the red. Nevertheless, I started off driving drunk, and therefore I am liable for whatever happens, even if what the accident ends up not being my fault, but because I did something wrong to begin with, so then I become responsible. In this case, similarly, even though it ended up going under the wall anyway, and so that would be beyond my control, but because I made an unstable wall to begin with, so I created, that's tchilato bepeshi'ah, and so I am liable, even though in the end it didn't break through the wall but went under it, I'm still going to be liable. So how come the Mishnah says that in this case, nifresa balayla patur, according to Rabba, that it went underneath, so it can't be that it's a solid wall, it can't be that it's an unstable wall. Now, there is another opinion that says, if I did something initially negligent, but in the end, what happened by accident. And so even though I'm driving drunk, according to this opinion, if the other guy passed the light, I would not be liable. So then this would make sense. We're talking about a case where it was a rickety wall, but so it's true, I was negligent, but in the end, the animal went under it, and so that was beyond my control no matter what. So that would make sense that Abba was saying, if it goes under it, even though I made a rickety wall, but it went under it, there wasn't nothing I could do about it, so then I'll be patur. So fine, we can understand Abba's statement according to that opinion, but that's not unanimous. According to the opinion that says, although I did something wrong, because I did something wrong, even though the animal went under it, but I made a rickety wall, so I am liable. So then, in what case would Rabbah say that I'm not liable just because it went under it? So what if it went under it? I made a rickety wall, So I should still be liable. Rather, we're going back to what we said. In fact, it's talking about a healthy wall, and that's why. And that's why I am not liable. And even if it didn't go underneath, but it went right through the wall, but I made a healthy wall, so I did what I was supposed to do, and therefore if the animal got away and caused damage, I am not liable. So forget the digging over here. Wouldn't even matter. But Rabbah said the limitation on the Mishnah regarding digging, he wasn't talking about this clause, he was talking about a later clause in the Mishnah. You see, sometimes we have statements from Moraim, and we know that it relates to this Mishnah, but we may not be sure about which clause in the Mishnah it's talking about. So the later clause is If I leave my animal in the sun, so it's unbearable in the sun, and then it's kind of inevitable that the animal is going to do anything it can to get out of the pen and to get out of the discomfort of the sun. That's the relevant part. Or also, if I give it to a cheresh katan and it goes out and causes damage, one is liable. But the main thing here is talking about the sun. Here it's not vehu, that in this version of Rabbah, but rather afilu. It says even if it dug under the wall and got out that way, I am still liable because I put it in a situation where it was unbearable in there and it was going to have to get out. Now, I don't have to tell you in a case that it didn't go under the wall but rather broke through the wall, got out somehow, that it's totally my fault because I put it in the sun where there's no way it was going to stay. Even if it goes under the wall, where I might have said I was negligent by leaving it in the sun is true, but in the end it went under the wall. Who could have? Going under the wall is like a tornado wind. It's very unusual that it would have the ability to go under the wall. So I might have thought that even though I put it in the sun, still going under the wall is not my fault. So therefore, according to Rabbah, this interpretation, the Mishnah wants to teach us that even in this case, I am liable because it's all negligent. By putting him in the sun, he's going to find one way or another to get out of the sun. And if that means going through the wall, over the wall, under the wall, I am the one that set that up for failure. My tamad medayadate kevan deshbakta behama kol tasdeka teit lal mebad abda benafka. The victim, the owner of the victim of the damage, will say to the owner of this ox that he left out in the sun, says, you should have known that since you left it in the sun, it's going to do anything it can to escape, even if it means unusual activity of like going under the wall, and therefore you are directly responsible. The next part of the Mishnah teaches Hosioha listim hayavin. If bandits came and they removed the sheep from my pen, and then the sheep get lost, or the sheep go and cause damage to someone else, then the robbers are liable. We ask, Pishita kevanda pekuakai mala b'shutehu lechol miles. Isn't this obvious? Why does Mishnah come teach us that? Once the thieves come in and they take the sheep into their own possession, that's it. It's in their custody, and they are liable for anything, like they're the owners. Once they take it, physically take it themselves, so then they're liable for losing it or for any damage that the sheep cause. No, we're not talking about a case where the thieves physically pick up the sheep and take them out, but rather they do it more indirectly by standing in front of them so that they can't go in one direction, and then the sheep is forced to go in the other direction out of the pen. So here it's literally it's walking out by itself, even though it's the thief that's blocking its way from going the other way. And so in that case, even though the thief didn't touch it, but did indirectly make it go out of the pen, the thief is still liable. That's the chidush. Ki hadamar Rabba amar Rabba Tana amar Rav hamamid behemat chavero al kamat chavero hayav ma'amid peshita la siricha dekam la be'apa. And this we know is true from the statement of Rabba, who said in the name of Rabba Tana, who said the name of Rav. If someone stands an animal on the grain of his friend, so he's like puts the animal there, and I didn't physically put my friend's food in its mouth, so it ate by itself. But nevertheless, I put it there, I am liable. Now we said, okay, if I put it there, obviously, I put my animal in someone else's field, of course I'm going to be liable. I don't have to stuff its mouth with it. And so we answered there, no, we're talking about a case where I didn't put it. I just stood in front of it so that it couldn't go in a place where it's allowed to go. And so I had to go the other way into someone else's field, and then it ate from there, and the one is liable even in that case. So if I stand as a pick and indirectly cause the animal to go where it's not allowed to go, that is still my responsibility, and that's what the thieves did here, and that's why they are fully responsible. Amar le Abaye le Rav Yosef hikisha amart lan velistim name dehikishuha. Abaye told Rav Yosef a different answer that you had said of Yosef when he was in his old age. He forgot some of his teachings, and then Bear reminded Rav Yosef of what Rav Yosef himself had said. And Bear said, you told us that this is talking about a case where the thief hit the animal, and by hitting it caused it to go ahead. So it's true he didn't pick it up or pull it, but he hit it from the back, and then that caused it to move out of the pen, and in that way he went out of the pen and into the thief's own property, and that's the chidush. Even though he didn't pick it up or pull it, but he hit it from behind, he is still liable. Baruch Adonai Leolam, Amen ve'amen.